Right, so we're sitting here with Sereca, who is going through the children's court case at the moment, currently being heard in the High Court, all part of the organisation called the Hood. How has it been? How has the last few days been for you guys, and where is the court case up to at the moment?
Well, the court case has been had. We've had our days in court. We had 2 days in court. And funnily enough, we were joking about the fact that it was quite a squash to get that into 2 days, to be honest. We all would have actually loved to have had something other than a judicial review, because we would have loved to have had everyone speak to the evidence that was there, because it would have been quite amazing. Quite a different case, but yeah, we were like, it would have taken weeks, like literally weeks. I would say that every expert probably would have been on the stand for a day or two each, plus all of the rest. So yeah, 2 days was cramming it in. Yeah.
What was some of the evidence presented on behalf of Pfizer that you found interesting?
Well, Pfizer didn't actually give any evidence, because Pfizer was just considered an interested party. So they were actually given the opportunity to speak if they wanted to. And Pfizer's lawyer, not Pfizer themselves, but Pfizer's lawyer, only had a very brief moment of commentary. And that was basically there to try to, they had documentation in there that was confidential, that we weren't privy to, as lay people anyway. The council obviously were. And so there were things that weren't to be disclosed in the hearing, because obviously it was streaming and we were in the courtroom and things like that. So there were things that were said and had between authorities and Pfizer that the average person was not allowed to know. So the only time that Pfizer had anything to say was just to protect that. They actually wanted to do some of the parts in chambers. So no, that Pfizer didn't have much to say. They were given the option to comment. I think they did comment at the end, but of no real significance. Again, it was just making sure that they represented her client and their interests. So yeah, Pfizer was a bit of a non-event really there. But
what about the Crown? Did they present much information on behalf of the Crown?
The Crown, yeah. The Crown didn't say anything unexpected. The Crown presented a lot of evidence that, I'm going to say this because this is a personal opinion. I felt like there were a lot of smoke and mirrors. And
what do you mean by that? Were there specific topics that they chose to bring up, or specific references to certain pieces that are coming from the scientists, or any particular studies?
It was mostly that there was an avoidance of certain things, like a notable avoidance of dealing with the fact that this was a novel technology. It was never mentioned once. There was never any, and at one point our council actually, and I probably would have used the same terminology, they sort of compared apples and oranges, like, because they tried to compare a flu vaccine with this mRNA technology. And it was picked up and defended by our council pretty quickly. It's like you can't actually compare the two, because one is completely new technology, and you don't have the safety studies and the trials and all of the rest of them in history to compare it. It's just not the same. There were a lot of things like arguing that the reason that the trial was so small was because of the fact that they didn't have the time. And in that situation, it's very normal to use the adult information, the studies and all of the information gained from adults. And our argument's like, yeah, but that was alarming. That was raising red flags. But I think the biggest thing about this whole case that needs to be kind of reminded, and it's hard to get your head around, to be honest, is because it is a judicial review and it's not a merit. So a judicial review, and I'm only recently schooled in this, is that it's not merit-based. So regardless of the argument for and against this product, it's about the decision that was made to launch it. And so there was a lot of discussion about safety, efficacy, all those sorts of things. But one of the things that the Crown was trying to point out, that they're defending that purely because we're raising so many issues, they don't actually feel, and I'm totally putting this in my own language, obviously, but they didn't feel that they really actually had to argue that, because the point of the case is to review the decision-making process. And so that is the crux of it all, if you like. Obviously, the information that was given to Mr. James, who is the director of the governing body, he is the man who signs or rubber stamps everything, as I put it. He is the director of Medsafe. He is the one that kind of gives it that approval. And I learned a lot actually in regards to that. And that is a huge foundation of our case, because that particular person is the one who's made that decision to roll this out and then advise the government that this is safe and effective, and that it is worthy of rolling out. And I guess the thing is our argument is that there's a very strong case to say that process was not followed properly. And there was a big finale, I guess, where our counsel, David Jones, who is our QC, he went over that very, very thoroughly at the end, really driving home the point that this wasn't someone stuffed up, someone is lying, there's something gone on, because you don't say no and then 4 hours later say yes.
Yes. Yeah.
All of that is rings fishy. And the thing is that when there's no, I mean, in a nutshell, for people who don't really know, I guess it's just, if you're going to say about the decision-making process, the biggest issue that there is that Medsafe were given information, that information was reviewed. Mr. James is the one who puts that stamp on, yes or no, and they found that information lacking. And so they said, and as our counsel points out, because Mr. James didn't actually write anything anywhere, he literally circled no and signed it. So what that does is it puts it onto another authority, which is an advisory panel. And that advisory panel, Mr. James does not participate in, because he has to keep some form of,
degree of separation.
Yeah, exactly. And so we didn't get, that was all redacted. We don't know who's on that panel, but we do know that Pfizer was in there. And that months worth, or a good month of decision making for Medsafe came out with, we find this lacking. And then 4 hours in a room with, I think it was 9 advisory people and Pfizer, and I don't know if there's anyone else, but I think that was about it. 4 hours in there, and that was sufficient to change Mr. James's mind. And the thing that is alarming about that is there were no minutes taken to see what was said, what changed anybody's mind, and there was no new information given. Something funky went on. Regardless of whatever it was, something fishy went on. And the thing is that there was some strange things going on, like that meeting was penciled in prior to the decision that was made, is my understanding. So there's a bit of premeditative decision making and premeditative kind of stuff going on there that seems a bit out of place. And there's just things going on. And the fact that there were no minutes taken of any of this. I mean, the biggest thing that we have issue with is it's all about transparency. You're working and making decisions for the New Zealand public. Not only are you doing that, but you're approving something for children.
Yeah.
So one would think that you would, if there was question, one would think that would be days and days, if not months of reviewing, a whole lot more data, whole lot more evidence required, a lot more, more experts. I don't know what they're going to do in that process, but one would think it would be more, not just a handful of people in a room where there's no record taken. And you would also think that to answer to the people, you would take minutes. This is how we changed our mind. This is why we changed our mind. This is logical. This made sense. And here you go. This is it.
Interesting that they'd put such a lack of thought into the process behind approving something for children that is a new medication.
It's alarming. It's alarming. And I mean, the thing is that there are a lot of things that I guess ring concerning about this whole process. As we know that the trial should have been redone once they changed the ingredient, regardless of how, you know, how small they believe that buffer change was, regardless it's a new technology. How can you guesstimate that something's going to be okay without actually testing it, regardless if it's been used in other products, other medications, etc., etc., etc. Not with this. We don't know, you know, and that precautionary principle is just this this line that we shouldn't be crossing with children. And I guess even for myself, I mean, I know that it's all through the evidence. So people need to remember that if they were watching, what they were watching was a very, very summarized version of thousands and thousands and thousands of pages of evidence. And I kind of went up to counsel in between and said, but why aren't we saying this? And they're like, it's in there, it's fine. We just need to hide out, you know, the chunky relevant bits. And to be honest, I was really, really impressed with David's ability to do that. He was slow, he was methodical, he was humorous at times that seemed to amuse the judge too, a little bit too. I think all of this equestrian kind of joking was kind of funny. And, you know, there was a real natural ease to his argument and a confidence to it. And he put it in such a way that it was easily digestible. And then you kind of got to the Crown's side of things. And I'm not going to speak ill of anybody, but it was very fast. You know, the delivery was fast. It was bouncing all over the show. And I actually felt for the judge a little bit. I was like, well, it's kind of getting hard to keep up. But I also still don't understand what international, I mean, I was always told here advocating for family court cases and even just in preparation for this, it's all about New Zealand data because it's what's relevant here. That's what we keep getting told, you know. And the thing is the Crown's own data was like predominantly international, bringing up alarming things like syndromes in children that I don't think we've had any cases of in New Zealand. And it's kind of like, but we're deciding for New Zealand. It's in New Zealand for New Zealand children.
Have they given you an indication as to how long it will take to have a ruling come out?
Yes, now we did actually clarify that. So as I said to the legal team today, now what you think is like quick, I don't think the New Zealand public think is quick because they understand the process. So the judge did say that he would try to consider this quickly. Now quickly in the legal sense is more like weeks. You know, it could be months, but more like weeks because he does take on board the urgency of this matter because there's safety involved and there's children involved. And he recognised that, which there's lots of encouraging things there in terms of his respect for Dr. Malone's position and defending that right, you know, to be heard. He saw no issue with anything that's presented to him by us. So, yeah. Yeah.
So 2 to 3 weeks, and then hopefully there will be a decision.
No, not 2 to 3 weeks.
Sorry, I thought that's what you were saying. Sorry.
No. 2 to 3 weeks would be like exceptionally quick. No, weeks. Meaning I don't want to say how many because it could be 4, 6, 12. I don't know. I know that one of our lawyers said one of her cases took a year to decide. That we don't anticipate that happening in this case because again the judge recognises it. But you've got to remember that there's I don't know, we had 5,000 pages of evidence prior to the Crown giving theirs in and then us replying. So I don't actually know. I don't even think Katie's got any idea anymore how many. But we did have to laugh because we were trying to figure out who the Crown Counsel were. We were standing outside the courtroom and a few obvious lawyers went in. We went, oh, okay. And then around the corner comes 3 women with massive suitcases. And we were like, that's our case. So there's a lot for this poor judge to go through. And I think it's encouraging. He really was interested in reading it. He asked a lot of really pointed questions, very interested questions. And I think he really wants to understand a lot of the points, which isn't easy when you're doing it.
So from here, how can people support you and what do you guys need to continue the case moving forward?
Well, we still haven't covered costs. I keep getting excited because we got to go to court, but the costs still rolling in. We obviously, with billing cycles and things like that. So we have covered costs which are historical. Now we've obviously got court costs. reply costs, etc., etc. So yeah, we don't have the mountain that we had to climb before, but we still have probably about a quarter of a way to go. So yeah, they can donate online as per usual on our website, and keep sharing, because the thing is that the thing that was really disappointing, and I really hoped it wasn't going to be the case, but we kind of knew it would be, there was no media there. Radio New Zealand came, it was encouraging. She was typing away, and she actually did okay at covering the bit that she covered, but that was it. It was like half a day and they were done and dusted, and then that was it. We weren't interviewed. I mean, far out. Why are these people taking if I was a journalist, why are you taking the crown? Like, what is there actual safety concerns? Should we be concerned? Should the people be concerned? None of that. This could have so easily have been brushed under a rug. The whole decision-making process was fundamentally broken, right down from legislation to the way that it was approved, to what was required to approve it, etc. Now, that part of the, obviously there's a very small parameter on which we are actually legally arguing that, which makes it a very difficult argument to win. But what it does do is it highlights that. And actually, one of the things I wanted to say, we were sort of joking about it with the lawyers today, is that we've already seen law changes after each one of these types of cases. So we will be very curious to see after a decision, depending on how the decision goes, if there's sudden law change or a legislation procedure change, because that's happened numerous times, and we have definitely highlighted flaws here, substandard requirements, the fact that minutes weren't taken in absolutely crucial meetings, and literally somebody's fudging something. You don't say, no, it's not safe, and then suddenly it is safe. Oh, but we did think it was safe, but we had to say it wasn't safe because we wanted these other people to look at it.
Yeah.
Even once all of this is done and dusted, people who are on the fence, people who don't believe that you could question safe and effective, because that whole statement has actually been proven to be false. That they cannot say that, they should not have said that. All of that will be in there. It'll all be on the website. It'll be public record, and it'll be very difficult to argue that.
All right, thanks, Sereca, and good luck to the Hood as well. We're behind you guys all the way.
Awesome. Thanks for your support, everybody.